Welcome back to Freedom Facts and Firearms. My name is Novak, and today we'll be looking at how English law was actually applied in colonial America when it came to carrying arms and what some of the differences were. So, how did English law influence colonial American law? Some colonies enacted laws against malicious carry. Massachusetts banned going armed offensively in 1694. New Hampshire ordered justices of the peace to arrest affrayers, rioters, disturbers or breakers of the peace, or any other who shall go armed offensively in 1699. While not all colonies had statutes specifically addressing carry, common law held that it was permissible unless done in an offensive manner or in a way that would bring terror to the people. In 1786, Virginia created a statute that no one may go nor ride armed in the terror of the country. So, as you can see, any restrictions thus far have only been for offensive purposes, with those carrying with the intent to take action in a criminal or terrorizing manner. There have not been any statutes in colonial America restricting any type of arms. Massachusetts would go on to be the first state to enact tougher laws on carry. In 1795, it amended its previous statute to include menacing words. It read, "All affrayers, rioters, disturbers, or breakers of the peace, and such as shall ride or go armed offensive to the fear or terror of the good citizens of this Commonwealth, or such others may utter any menaces or threatening speeches, should be arrested." This law was more violation of the First Amendment than the Second, and it didn't restrict arms, it just expanded the restrictions on what actions you could do while in possession of them. While much of the English law and tradition of firearms, carry, and self defense was either used as law or inspired laws in America, much of it was altered or outright rejected as well. The founders rejected the English Bill of Rights as being too weak. They had much stronger reliance on firearms and pushed for much more freedoms with them. We'll cover more of this as we focus on the colonial time frame in a future episode. But these ideals were first solidified by the Tennessee Supreme Court in 1833 in the case of Simpson v. State. The charge in the case was that Simpson was in public armed in a warlike manner. The Tennessee Supreme Court would go on to expressly reject Hawkins' rule that nonviolent carry of dangerous and unusual arms could constitute an offense, and states that such an offense came from ancient English statutes enacted in favor of the king, his ministers, and other servants, especially upon the statute of Edward III. Our ancestors, upon their emigration, brought with them such parts of the common law of England and the English statutes as were applicable and suitable to their exchanged and new situation and circumstances. Yet most assuredly the common law and statutes, the subject matter of this fourth section, formed no part of their selection. Alternatively, if the Statute of Northampton had become part of American common law, our Constitution has completely abrogated it. It says that the free men of this state have a right to keep and to bear arms for their common defense. The Tennessee Supreme Court found that the Statute of Northampton and the ancient statutes and common laws of England on which influenced the laws of America held no weight, were expressly rejected by the founders and Americans, and even if they were somehow applicable, the state constitution abolished its use. It's also important to note that this applied to dangerous and unusual weapons, not just common arms. What's more significant about this case in light of the Supreme Court's 2022 Bruin decision is that while this case was decided in 1833, 42 years after the Second Amendment and the 1791 historical context that courts must now use, Some of the founders and framers were still alive, the most significant being James Madison, who introduced the Bill of Rights, noted that it was the private rights of individuals the Second Amendment protected, and was the fourth President of the United States. Also alive was Noah Webster, who created the first American English dictionary and set forth modern English and encapsulated the meanings of the words used at the time. So this court had access to two founders that played critical roles for interpreting the Second Amendment if it had felt it necessary to do so. Following this ruling in 1836, the state legislature of North Carolina abolished all the statutes of England or Great Britain. In 1843, State v. Huntley would further clarify arms carry in North Carolina. Huntley had armed himself with multiple guns, knives, and other weapons, and openly in day and night made threats to beat and kill a certain man. Huntley felt that since the Statute of Northampton no longer applied, he committed no crime. Obviously, he was wrong, and the court held that common law prohibited riding or going about armed with unusual and dangerous weapons to the terror of the people. The court went on to clarify that a gun is an unusual weapon, but although a gun is an unusual weapon, it is to be remembered that the carrying of a gun per se constitutes no offense. For any lawful purpose, either of business or amusement, the citizen is at perfect liberty to carry his gun. This is a great ruling by the court. Although they claim a gun is unusual, which at the time and especially now it certainly is not, they noted that carrying a firearm for lawful purposes and amusement was perfectly acceptable, which kept with the tradition of arms carrying since the 1600s when the first colony was established, and shows that there was no restriction on owning unusual weapons, which modern courts have got wrong over and over and accomplished by misstating laws and history. There was never a restriction to what types of arms a law-abiding citizen could own from 1600 until 1934 when the NFA was passed. In 2012, the Seventh Circuit struck down Illinois' ban of carrying guns in public. Illinois, trying to rely on the Statute of Northampton, failed to convince the court. The court ruled that some weapons do not terrify the public, such as well-concealed weapons, and that the Statute of Northampton only banned arms carrying in certain places or by large assemblies. Moore v. Madigan. Once again, a statute from another country and made before the official discovery of North America was used by a state to justify a ban and by a federal court to both in part reject that ban but uphold some restrictions. How does a statute from the 1300s, made by the King of England and outright rejected by the founders and proven invalid in previous cases, have any weight in the United States today? Once again, in United States v. Taut, 1942, the Third Circuit used the Statute of Northampton to make the point that weapons bearing was never treated as anything like an absolute right by common law. Again, a statute from the 1300s and from a different country was being used to determine U.S. law. The founders are documented as having stances in direct opposition to that ruling. Early colonial laws also contradict that ruling, and court cases we have just talked about ruled the exact opposite as well. In 2016, the most corrupt court in the U.S., the Ninth Circuit, used the Statute of Northampton in Puerta v. County of San Diego to support that there is no constitutional right to concealed carry. The decision was 7-4 in an en banc panel. Again, in 2021, the Ninth Circuit would again use the Statute of Northampton in the Young v. Hawaii case to state that the Second Amendment allows the government to forbid all carrying of arms outside one's property, including open carry. They further perjured themselves by stating this was understood in the American colonies and in the states during the 19th century. This was a blatant lie, as not only did the 1833 Simpson v. State and 1843 State v. Huntley case give judgments stating the exact opposite, but the colonies prior to the establishment of the United States had laws that were explicitly in contradiction to what the Ninth Circuit ruled, and the Ninth Circuit could not cite any case from any jurisdiction that could support their ruling. So, as you can see, there have been no restrictions on the type of arms one could possess. The only restrictions have been on which types of arms may be publicly carried and in what manner they must be carried. Dangerous and unusual arms that could incite terror or panic at their mere presence were not allowed, and the carry of arms open or concealed was only forbidden when doing so in an offensive or terrorizing manner. Our courts continue to misstate the laws and history of our country and create restrictions where none ever were. This is why knowing your history and laws is so important in bringing down unconstitutional laws and weak political talking points. I hope you enjoyed this episode of Freedom, Facts, and Firearms, and will join us next week as we touch on historic laws against armed public carry and disarmament.